Hey Realty Brokers, this is Timothy King, and I want to talk about the 2022 real estate contracts. This one is the real estate contract residential. Just want to walk down through here and have a few thoughts. The parties, obviously, it says here, the buyers, and so buyer, here, and then you would scroll down, maybe their legal name, I would just say. Legal names. So you've got two lines here. You can put in several legal names. Single family home, manufactured home, builder owned more than a year, 1 to 4 attached dwellings with land or condominiums. Typically we're going to do single family homes, and that's a regular home detached with land. Legal address and legal description. The mailing address of the property. I'm going to assume it's in Pulaski County. It could be Lonoke County. It could be any county in Arkansas. But this is very important, this legal description and how you do it. The mailing address, that's where the mail goes, and street address, Then Pulaski County, Arkansas. And then there's a section, township, and range in the tax records. Awesome View subdivision. Also on the tax records, there's usually a subdivision listed. Even if it's out in the country, it may have like the section, township, and range. If it doesn't, if it's blank, just leave the subdivision off. And a lot of times there's a lot and a block. Not always. And again, if it's not there, just leave that off. But definitely section, township, and range. That tells everybody where in the United States where to start looking. Also Pulaski County, what county, and the state of Arkansas. This line is non-negotiable. This has got to be there. And a lot of times, most of the times, 99% of the time, you need to put basic descriptions such as 1 tax parcel, 2 tax parcels, 3 tax parcels of about 1.5 acres or 8.5 acres with a home and a utility building, or a basic description of what is included in the sale. Then there's purchase price. It could be new financing, could be the price. It could be down here, it could be cash. It could be $500,000. Could be that, just cash. And so you just, however they're paying for it. And sometimes if you don't know and you're writing, you don't know what kind of loan it's going to be. If they're borrowing the money, then you put in the purchase price here, and do not be shy about calling their lender, texting, emailing, or calling their lender, even on the weekends. A lot of times the lenders will answer you right back very quickly that it's a conventional loan, a VA loan, FHA, or what it is. And sometimes you may, this is the easy way out, you may have to say to be determined by lender. However, if you're in a competition, on a contract, and you have a conventional loan, and the next person has an FHA loan, FHA is way more particular on their inspection, FHA appraisal inspection, than a conventional. And so a lot of times a buyer, if they know you've got a conventional, they may choose your contract over the other one, the FHA or the VA, simply because they know that there's peeling paint, or there's other things about the real estate that they would have to fix if it were a VA FHA type loan. So this can be extremely important. So don't be shy about calling the buyer's lender. Get their permission and call them. The next thing on page 2 is if a loan is a VA loan, you would click this or not. If it's not, if it's FHA, you would click this and you would put in the purchase price here. in this slot here. Almost always click this, even if it's not FHA, and we're going to send them, you're going to send them, somebody's going to send them for your protection, get a home inspection. It's one of our forms in our real estate contracts. It's easy to click on and get signed at the same time you get the real estate contract signed. Always, for your protection, get a home inspection. I use it. This brokerage uses it, whether it's FHA or not. Agency. Now, agency is probably the biggest complaint area, is not knowing if people saying they don't know if they've been properly represented or not. So this agency is also another thing, and we'll get more disclosures signed on agency. You know, if you're dual agency, that would be listing firm and the selling firm. The selling firm, you know, is the buyer's agent. Buyer's agent, selling firm. The listing firm is that agent who goes out and gets a listing and puts it on the MLS. You know, if you got dual agency going on, then you got the buyer and the seller, and then you know, it would go here. If you're just representing one or the other, you would click this one here. There are times when you know, it might work out this way that the buyer is not represented. They just want to work through you, but they don't want to sign a buyer's agreement. And I've got one right now. The selling firm represents the buyer because the seller doesn't want a listing firm. And also, this would be a for sale by owner type situation here. And this non-representation, we don't use that in this brokerage. Loan and closing cost. Again, when you're talking to that lender, find out what kind of, what type of loan it is going to be, and also ask if they're going to need to ask for closing cost from the seller. So, you know, shall be paid by the seller up to the sum of, you know, let's just say $5,500. That's not uncommon these days. So that's only if. Now again, this right here will weaken. That'll weaken your offer right there. If the seller says, "Man, I got to give them $5,000," and it's an FHA, that means, man, I got to give them $5,000, and FHA may require me to spend several $100s or even $1,000 fixing certain things. The windows have to be operable. There's no peeling paint. There's just a lot of FHA requirements. So again, if you put this in here, it's not a freebie. This could lose the contract. You need to explain that to your buyers. Your buyers need to also understand these paragraphs that don't need anything filled in, such as application for financing within 5 business days from the acceptance of this real estate contract. An application is defined here. You know, they need to give several things in order for an application to happen. Earnest money is another thing. If you do submit earnest money, there is an earnest money addendum that you'll also need to fill out and submit with the contract. Non-refundable deposit. Let's talk about that for a second. I love using a non-refundable deposit in a couple ways. One, the non-refundable deposit is exactly that, non-refundable, unless it's you know, you can read this, and the deposit is not refundable to buyer unless failure to close is exclusively the fault of the seller, or if the seller cannot deliver marketable title to the property. So if they can't deliver marketable title, the buyer gets the money back. And if the seller, you know, just keeps working or causing problems that we can't get the deal closed, then the buyer gets their money back. So read these things carefully. The deposit is not applicable is one thing, so you would normally say that and that a lot of times on most contracts. But let's talk about this. I love using a non-refundable deposit in order to do two things sometimes. If I am the seller, I would like to get a non-refundable deposit for the seller, for my client, the seller, somewhere around 3 to 5 days, about 5 days minimal before closing, before the closing. Here's why. If you've stared down a client that has moved all of their stuff into a U-Haul truck, and now 2 or 3 days before closing, the buyer suddenly doesn't qualify because they went and bought a new car, or they got dental implants. That's a recent new thing, was dental implants, and they ruined their credit. Now they can't close on the house. But the seller has loaded everything up. It's boxed up, loaded up, and on the U-Haul truck, and now we can't close. And they're looking at you, the agent, looking at me. Well, why didn't you protect me from this? Well, that's happened to me a number of times, and it is no fun. It'll make you lose sleep. And not to mention what your seller, the sleep they're losing. So a non-refundable deposit about 5 days before closing would solve that problem. If I can get a non-refundable deposit of maybe at least $2,000, $2,500, or about $5,000, just anything significant. Let's see here. I would say 5 days, within 5 days prior to the closing date. So this gives the buyers all the time in the contract to do their inspections. It's a very fair arrangement. Very, very fair. Do all their inspections, do everything they need to do, and within 5 days prior to closing, we need a $5,000 non-refundable deposit written out to the seller. That way, even if the stuff gets on the truck, even if it gets on the truck, everything, and the buyer defaults, terminates, the seller still has $5,000 or $3,000, $4,000, $5,000, $6,000, whatever. They still have some money in their hand for the damages. Damages are labor, loading a truck, renting a U-Haul truck. You get the picture. Title requirements. They reworked this for 2022. I like it a lot better. Typically, we're going to do this where the seller provides title insurance in the amount of the purchase price. However, I've had some contracts coming through lately, a number of them, where the buyer and seller split the cost of a combination owner and mortgagee's policy of title insurance. They split the cost. That'll sweeten the deal a lot of times also. Survey. Try to always get a new survey. And if your person just says no, maybe it's a home inside the city, been there a long time, and it doesn't matter. Surveys can change, and what goes overhead and what goes under the ground can change on a moment's notice. And the buyer, your client, needs to know what is involved in the dirt, under the dirt, over the overhead that's affecting that real estate. So a new survey, I encourage it 100% of the time. You know, a lot of times if they're writing a full price offer, you might ask for the seller to pay for a survey. If there's a lot of competition, you might just get the buyer to pay for the survey. Usually, you know, on a city lot, it's $300, $400, something like that, or at least split the cost on a survey. If there's no survey, then we will be sending a waiver. I had an attorney provide for me a waiver of survey agreement for the brokerage, and that is in our Form Simplicity. And if there's no survey on that, me or my wife, Anel, will be sending out that waiver for sure. If you can go ahead and get it signed, the waiver, then all the better if there's no survey. That way, it's here in the contract, but it's also on a separate document in case we ever get sued. And that it happens from time to time. Someone will say, I didn't know. Well, I didn't know. Well, I didn't know, and my agent didn't tell me. So if we have at least 2 documents signed that's saying, I don't want a survey, the judge is going to say, most likely, well, you signed more than 1 document, and you still say you didn't know? So it's just risk reduction. I'm sure y'all know what prorations are. And then these fixtures, you know, like front porch swings, just hanging there. So make sure you cover the things that, like a front porch swing. And I tell you what, I don't think I've gotten a front porch swing in the last 2 years. Everybody takes it with them. They're like, oh no, you're not getting the front porch swing. That was grandma's. So front porch swings are quite the thing, it seems like. Contingency, you know, selling a house or selling something in order to buy something, that's what a contingency is. And so again, if you press contingency, even if you got a good price, a lot of times a seller will say, no, I'm not going to tie up. I'm not going to tie up my house or whatever waiting on something else to sell, because it may never sell. So a contingency will really weaken your contract. So it's better no contingency. I'm not saying don't submit a contingency. I'm just saying it'll probably greatly weaken. So you got an escape clause, or you got without an escape clause. Home warranty. You know, I'm seeing a lot of contracts come through without a home warranty, and letting the buyer just buy their own home warranty. And so ask your buyer what they want to do. Again, another $600, $700, $800 out of the purchase price, plus a survey, plus whatever closing costs. You can really take out, you know, $5,000, $6,000, $8,000, $10,000 out of an offer, which weakens your offer big time. So kind of talk this over well with your client, your buyer, and see if they want to ask the seller to provide a home warranty, or if they just like to buy that themselves. Inspection and repairs. This first one is talking about as is, where is, all false bases. You know, it's an as is deal. But you realize you're declining rights for your client. So even if it's an as is situation, please check B, 16B. That way your client has the right to go to the home maybe more than one time, maybe 2 or 3 times prior to closing, and walk around and look around, measure, maybe get a second opinion. That is proper representation of your client. And you need to read the rest of this page also. Please take these contracts and print them out, and in the evening maybe, you know, get you a cup of coffee in the evening or something, and sit down and read through these. You take a marker pen or something and read through and mark them up. If you got questions, then call me, and let's talk over what your questions are. That's not just this contract, that's all the contracts that you will use. Seller property disclosure. This has gotten way more involved this year. There's a lot more interactions. So there's the seller property disclosure, and you'll check A, B, C, or D. Termite, if there is a mortgage or a loan or a lender involved, 99% of the time there's going to be a letter clearance requiring a termite protection contract with a 1-year warranty to include treatment if allowed by applicable law. Now, I want you guys to understand something. If you don't specify that it is a termite protection contract, they may just give a some of these termite companies, they'll just sign you up for the cheapest price possible, but there's no real insurance involved. So read this contract very carefully and make sure that the title company is providing a termite protection contract with a 1-year warranty to include treatment if allowed by applicable law and Arkansas State Board and full protection plan provided by the seller at the seller's cost at closing. So if you're not careful, the termite companies will scam you. They'll give you a cheap price or charge you full price, but if you don't specify that this is correct, then they won't give you insurance, if you will, with a treatment 1-year warranty for treatment. So verify the termite protection. So it's more than just a letter of clearance. It's a termite protection contract. Number 20, lead-based paint risk assessment for inspection. A is properties that were not constructed prior to 1978. So, a lot of homes we get into, they're built in 1978, 79, 80, or later, and that doesn't fall under the federal lead-based paint requirements. However, if it's 1977 or earlier, then we will have to have, this is a federal requirement, federal law. We could end up in the U.S. Marshals' hands talking to a federal prosecutor, and the penalties are pretty stiff, very stiff, if we don't obey or abide by the lead-based paint risk reduction acts. So anyway, it's no big deal. If we do it right, we have nothing to fear. Just get it signed. Make sure we don't skimp on the date, and make sure we verify and that it was built after 1978 or after 1977, really, and make sure that is correct. I mean, if you got a house and on the tax records it says it was built in 1985 and you look at it, it was built in 1940s, just remodeled in 1985, which happens on the tax record sometimes, but you just know it's been there, then let's just go the extra mile and provide a lead-based paint risk reduction or assessment. Just go the extra mile and do it anyway. Can't hurt, right? Insurance, the homeowner, the buyer, needs to obtain homeowner insurance within 10 business days after the real estate contract acceptance. So they get onto it. It's not the last minute thing. I've had buyers say at the last minute, the week of closing, say, oh, insurance is way more than I thought it was going to be. I can't buy this. And they back out of the deal. Well, the real estate contract says get her done within the first 10 business days. So that's the same thing as the 10-day inspection. 10-day inspection, also get some other things done like apply and get prices and bids on the homeowner's insurance within the first 10 business days, okay? Get her done up front. To ask and coach your buyers to do these things. Number 22. Now, you know, if there's a non-refundable deposit out and they at the last minute can't get, or flood insurance is required, or whatever, there's problems with the insurance, and they didn't do so within 10 business days, the buyers might lose their non-refundable deposit. All right? So the fine print in this contract is very important. Last, on page 10, closing. Again, about 32 days is the magic number, 32 to 35 days, calendar days from contract to a closing date. So, if they're pre-approved, sometimes you can ask the lender, you think we could do it earlier, like 20 days? And sometimes they'll say, yeah, I think we can. And they do. So again, talking to the lender, getting permission from your buyer. But let me tell you, by federal law, you're not allowed to discuss their interest rates, their financial situation, their financial history, their background. Those are not things you talk to the lender about. Don't go there. But you can talk to their lender with their permission, get it in writing like an email or a text, and keep the permission, put it in form simplicity for us all, like the email, print the PDF and upload it in form simplicity, the permission. That way we've got it in writing. Then you can call or text or email the lender and say, what kind of loan, do they need closing costs back? What closing date do you think? How quick can we get this done? Possession upon the closing is golden. So on the day of closing, the seller sells it and hands the keys over. The buyer buys it and gets the keys. Delayed occupancy. I've had several of those. It makes me nervous, but it's worked out in the past year. I've had several of the early occupancy. Again, it makes me nervous as a broker, because if somebody doesn't do what they're supposed to do, then everybody else, you know what I mean. They can all get fussy. By the way, if there's a delayed possession, read that delayed occupancy addendum. I think it's not supposed to apply for any longer than 30 days. So if it goes any longer than that, then you've got to have a lease agreement, a rental lease agreement in place. All right, read all these other things. Here's the other section. Do not wax eloquent and try to be an attorney if you're not one. If you're not an attorney, don't try and impress anybody with all your thuses and shalls and what have yous, words that attorneys use. Don't do it. If you're not an attorney, then don't try to be an attorney, because you ain't one, right? But in this other section, this is where we can put something down and keep it simple, stupid. KISS. Keep it simple. Keep it simple, stupid. I'm not calling anybody stupid. That's the acronym. Keep it simple. So, one sentence, not a paragraph. If it takes 2 sentences, fine. Just think about your sentence. Make sure it's very clear that anybody can understand it. And especially make sure that if we stand before a judge, it is plain and simple and clear as a bell to the judge. Keep it simple. Make sure it's clear. And I always, when I'm writing these sentences, I always think, will a judge understand this and know what I'm talking about? Just ask yourself the question. It's not as much what would Jesus do here. It's more what would a judge prefer, for me to write down. What would the judge appreciate? So a very simple, direct to the point, clear sentence. And avoid pronouns. Please avoid pronouns. Things like he, she, they, do not use that. In a court of law, they'll spend hours debating who they is. And what you need to do is say buyer or seller, you know, or a name. You know, these are the, you know, the nouns you need to use in any kind of a contract like this. Do not use pronouns. If I see pronouns, if I spot it before signature, and I will always send it back to you. I will not sign a contract with pronouns. It's too ambiguous. License, most of the time, the people we represent are not going to have a license. However, if you're doing something, or you know there's somebody involved that has a license, then you might want to use B or C. And there it is. This contract is executed. If you're writing it on today, then just go ahead and put that down, and then always make sure that on the e-signature that the buyers and or the sellers make sure that they sign and date. Sign and date. You know, sign and date down here at the seller. Sign and date down here. Make sure they're always signed and dated. And fill in the other things also, such as realty brokers or whatever. All right, well that's that. And by the way, people always say, well the expiration date here, you know, it's expired. You know, it's expired. It's the 26th. It's 8 o'clock the next morning. Do we need to write another contract? The answer is no. Don't need to write another contract. If you're a little over on the expiration, you can still accept the contract. It's fine. If you're a month over the expiration, we probably ought to write a new contract. With lawyers and judges like this word reasonable time. So, you know, if the next day is reasonable, 3-4 days later is still reasonable. You know, if everybody agrees and everybody is, you know, everybody accepts it and agrees and ready to move forward, then everybody sign it. Let's go. Sign and date down here on page 12, and let's rock and roll. It's okay. That expiration date does not expire or terminate the whole contract. All right, guys. By the way, one last thing. The bottom of page 12 down here, please get, if it's not accepted up here, if it's not accepted, then please get rejected or counter-offered. We need every contract written needs to be accepted, rejected, or countered, or terminated. Right, a termination. What we just got to, we got to put in writing the status of every real estate contract. That way nothing's laying around and something to come back and bite us. Okay, guys, hope this helps out, and we'll talk to you later. Bye-bye.